Extracted from Scotland's Magna Carta, the Claim of Right in the Common Law, by Professor the Right Honourable Sir David Edward, KCMG, QC, FRSE. Scotland's Magna Carta, if we have one, is the Claim of Right 1689, contemporary with but significantly different from the English Bill of Rights. The Claim of Right deserves attention for at least two reasons. First, that it enunciates more clearly than the Magna Carta or the Bill of Rights the constitutional principle that the monarch is bound by the law. Second, that it enunciates some basic principles of due process that are in danger of being forgotten today. The Bill of Rights, adopted in February 1689 as the Declaration of Right, and enacted by the English Parliament in December as the Bill of Rights Act, proceeded on the basis that King James II, by fleeing the country, had abdicated the throne. The throne was therefore vacant. This made it possible for the Parliament to offer the crown jointly to William of Orange and his wife Mary, daughter of James II. The Declaration of Rights stated the conditions, including basic liberties, on which the offer was made and accepted. It's often said that with the deposition of James II we got rid of the Stuarts. On the contrary, Mary II was an extremely popular monarch with whose death inspired Purcell to write some of his finest music, was undoubtedly a Stuart, and conducted business with firmness while William was away in his campaigns, including arresting her uncle Clarendon for plotting to restore her father. William III himself was a grandson of Charles I, and if any of Queen Anne's 10 children from the 17 pregnancies had survived, it might have been unnecessary to import a king from Hanover, himself the son of a Stuart mother. In short, the objection was not to the Stuarts as such, but specifically to King James. The constitutional problem for the Scots in relation to King James as James VII of Scotland was that he had not been physically present in the kingdom, and could not thus have been said to flee from or have abandoned it. So his removal and substitution of William and Mary had to proceed on a constitutional basis rather than of constructive abdication adopted by the Bill of Rights. The solution is set out in the Claim of Right Act, an Act of the Estates, the Parliament of Scotland, which is still in the statute book as Claim of Right Act 1689. It's widely believed that the Claim of Right reflects the philosophy of George Buchanan, tutor of young Mary Queen of Scots, and later of her son James VI I. Far more attractive and interesting character than his gloomy portraits would suggest. Buchanan was, by universal consent, the greatest Latin writer, whether in prose or in verse, in 16th century Europe. Montaigne was another of his pupils, and he was friendly with and greatly admired, and most of the great scholars of the period. Some of his verse, assuming that its Latin indelicacies were understood, would not be recited in polite drawing rooms. In his book De Jure Regni Apud Scotus, which was considered so dangerous that it was burned in the University of Oxford in 1683, Buchanan set out his doctrine that the source of all political power is the people, and that the monarch is bound by these conditions under which he was entrusted with supreme power. History might have been different if King James VI had paid more attention to what he had been taught. The Claim of Right falls essentially into four parts. There is a brief but important preamble. The second part then sets out the complaints against James and concludes that on these grounds he's forfeited his right to the crown, so that the throne is become vacant. The third part, picking up on these complaints, declares that a number of executive actions are contrary to law, and insists, somewhat ungrammatically, upon these as their undoubted rights and liberties. The fourth part expresses confidence that King William, now King of England, will preserve the rights so asserted, and resolves to order the crown of Scotland to William and Mary. The primary complaint against James, set out in the preamble, was that he had invaded the fundamental constitution of the kingdom and altered it from a legal limited monarchy to an arbitrary despotic power, and had exercised that power to the subversion of the Protestant religion and to the violation of the laws and liberties of the kingdom. Then there follows a list of particular wrongs committed, all of which are said to be utterly and directly contrary to the known laws, statutes and freedoms of this realm. This leads to the conclusion that King James has forfeited the right to the crown and that his throne is consequently vacant. The claim then narrates that William, Prince of Orange, now King of England, having delivered the kingdoms from popery and arbitrary power, had invited the Scottish estates to take steps to establish that their religion, laws and liberties might not again be in danger of being subverted. So the estates, being now assembled in a full and free representative of this nation, do in the first place, as their ancestors in like cases have usually done for the vindicating and asserting their ancient rights and liberties. Declare. There follows a list of the executive actions that are contrary to law, and this leads to the resolution to invite William and Mary to assume the crown of Scotland. There are a number of provisions in the claim of right that one would not wish to reassert today. The verbose enumeration of the evils of popery and insistence upon the rights and prerogatives of the Protestant religion compares unfavourably with the simplicity of Article 8 of the Articles of Capitulation, by which the Dutch surrendered New Amsterdam in 1664. The Dutch here shall enjoy the liberty of their consciences in divine worship and church discipline. Likewise, the statement of the claim of right that using torture without evidence or in ordinary crimes is contrary to law, to say the least, is surprising. But torture did not become illegal in all circumstances until the passing after the Union of the Treason Act 1708. And it is well that it is no longer necessary to protect husbands against being fined for their wife withdrawing from the church. The claim of right, like Magna Carta and the Bill of Rights, has to be read in its historical context, but with some of its provisions having a contemporary resonance, particularly in the context of the Supreme Court's repeated reminders that legal protection of fundamental rights did not begin with the Human Rights Act. Dicey and Ray, in their thoughts on the union between England and Scotland, interpret the claim of right as being, in effect, a demand for every power belonging to the Parliament of England. It's supposed to be the Parliament of Great Britain. But there you go. Far exceeding any power which the Parliament of Scotland actually possessed and exercised before the Revolution of 1689. Whatever the motives, the words used are surely capable of a more generous interpretation. The justification for declaring that James has forfeited the right to the crown relies on the antithesis being a legal limited monarchy and an arbitrary despotic power exercised to the violation of laws and liberties of the kingdom. A legal limited monarchy is a more explicit description of the constitutional position than is to be found in the Magna Carta or the Bill of Rights. The monarch is bound by the law, and her powers are limited by the law, an idea that might, with profit, be drawn to the attention of those of the Queen's ministers who seek to limit access to judicial review of executive action. The almost metaphysical conception of law as standing beyond and above, found today in the Treaty of the European Union, has been stated by Lord President Stair, the first and greatest of the Scottish institutional writers. No man can be a knowing lawyer in any nation who hath not well pondered and digested in his mind the common law of the world, from whence the interpretation, extensions and limitations of all statutes and customs must be brought. Law is the dictate of reason. It follows that that which is lawful cannot be arbitrary or irrational. A principle already present in the Wednesbury criteria and developed in more detail with the EU administrative law derived from German law, insisting on the objective justification and proportionality of executive action. For recent examples of how this idea is given effect, see in particular the judgments of the Supreme Court in R v Gull and Begel v DPP, which illustrate the evils of overbroad discretionary powers, as well as the importance of not relying on answers given under compulsion. The reference in the claim of right to the estates as a full and free representative of the nation, whether or not it reflects the constitutional philosophy of George Buchanan, cannot surely be interpreted as a demand for sovereign parliamentary power, still less the power of the parliamentary majority for the time being. It is rather an assertion that ultimate power rests with the nation, of which Parliament is but the representative, an idea that is taken to its logical conclusion in the opinion of the German Constitutional Court on the Lisbon Treaty. The claim to represent what the people want is often exploited in the corridors of Parliament at Westminster and Holyrood, under the guise of representing the nation. Dicey was perspicacious in his prediction in 1915 that the result of a state of things which is not fully recognised inside or outside Parliament is that the Cabinet, under a leader who has fully studied the arts of modern parliamentary warfare, can defy, on matters of the highest importance, the possibility of certain will of the nation. Passing from the general to the particular, we should note 4 types of executive action that are said by the claim of right to be contrary to law and do not figure in the English Bill of Rights. First, imprisoning people without expressing the reason thereof, and delaying putting them to trial is contrary to law. Here one thinks of the inhabitants of Guantanamo and perhaps some of those held in Belmarsh. The Virginia Declaration of Rights in 1776 was even more explicit in asserting that an accused person has a right to demand the cause and nature of his accusation and to be confronted with his accusers and witnesses. We're entitled to be satisfied that provisions for detention without charge or trial and for secret trials, and more particularly the way they're used case by case, are objectively necessary for a legitimate public purpose and their exercise is proportionate. Second, sending letters to the courts of justice ordaining the judges to stop or desist from determining causes or ordaining them how to proceed in causes dependent before them is contrary to law. Of course, all judicial decisions are legitimately open to comment and criticism, but more than one Home Secretary sought to tell the judiciary how to apply or how not to apply the Human Rights Act. And there is an increasing tendency to invoke the doctrine of parliamentary sovereignty, which properly applies only to duly enacted legislation, to justify ministers and other politicians criticising or even abusing judges for disregarding their view of the law and how it is to be interpreted or applied. Third, another assertion of the importance of judicial independence, changing the nature of the judge's gifts ad vitam aut culpam into commissions jurante bene placitur is contrary to law. The Latin phrases assert the distinction between appointment of judges for life, now until statutory retirement age, or removement for misconduct, and appointment for only so long as the executive is well pleased with what they do. Protection of the judiciary against discretionary interference by the executive with the financial or other conditions of appointment and tenure remains an important element in the constitutional separation of powers, unless you live in Scotland. Fourth, the claim of right declares that 2 judicial decisions of the Lords of Session were contrary to law. One of these had held that persons refusing to discover or disclose what their private thoughts and judgments in relation to the points of treason and other men's actions are guilty of treason. As the Investigatory Powers Bill passes through Parliament, we may legitimately demand, relying on the claim of right, that Big Brother will not be one of the reapers in harvesting of data, and that our private thoughts and judgment are to other men's actions will remain immune from intrusion in an inquiry. Section 19 of the Terrorism Act 2000 has already breached that dike. In conclusion, the claim of right is entitled to stand alongside Magna Carta and the Bill of Rights as a formal assertion of the principle of lawful limited monarchy and of the fundamental rights of due process and judicial protection against arbitrary executive action. Fervent as have been the expressions of admiration of Magna Carta, we may rightly demand respect for those other, more explicit expressions of the common law tradition.